Good morning. This is Hap May with a Legal Play.
And I'm Chelsea El-Azzi, Hap's associate. So Hap, this morning I want to talk about mostly partnerships, but it can come into play with management of LLCs, limited liability companies, and corporations. But mostly I'm going to try to focus on the context of partnerships. And our overarching topic is the battle for control.
Okay.
And what I mean by that is we've had a client come in who, and we've actually had a few
mini clients. My career, mini clients.
We've had quite a few of these where often it's two people. You might have seen, one where there's more, but we see more of them, I think, when there's two people who come into a partnership, and usually
each owning 50%.
Mm-hmm.
And yes.
And usually at the beginning, you think, we are both friends. We've got this great idea. We work well together and we're going to get things started. And so their agreement tends to be just kind of this, some standard template form, but it often only takes into consideration the positivity. We're going to do well. We're going to make money. We're always going to agree and things are going to be great.
Right.
And there might be some things down the road, XYZ, that'll cause us to dissolve.
And we're just going to split the money 50-50.
And we'll work it out if we get there.
Right.
And then what happens is there's a disagreement. You guys, the partners.
Yeah, and one of two things happen, either failure or success, either of which cause problems for partners. If it's failure, well, gee whiz, you got to pay this. I don't have any money. You got to pay this. Or it's your fault, not my fault. I worked hard, you didn't. I put in money, you didn't. I mean, that's I had my contact base, all my friends and family and contacts, with the business, but you screwed them up because you didn't do the. I mean, there's all kinds of disputes that happen with regard to that, and that's the failure scenario. Yeah, so where each blames the other one, and each whatever liabilities are, the other one wants to force the other one to pay, or when there's a pay cut, the other guy's got to take the pay cut, and I don't. And
stuff like that. It doesn't even have to be that extreme. The client I'm thinking of right now just can't seem to get on the same page with her partner. Like one wants to do it this way, and it's not a bad way. It's just the other partner's like, yes, but that's not the way I want to do it. That's not and they just keep. And I don't think it might be impeding business,
It might be, and it's.
But it's definitely gotten to the point where neither one of them is very happy with just the workflow.
And everybody would be happy if they find a way to split up in the process, but splitting it up is a complicated process. So and that happens. So the other thing is success. I mean, when you have lots and lots of things, and one of them wants to sell out, the other one doesn't. The other one wants to, now that they're doing well, wants to take it easy. The other one has a different workload than that.
Mm-hmm.
Whether they take on more debt or pay off debt. I mean, there's all these things that come with success in the process that can create divisions among two people, or it could be more than two people. But generally speaking, the classic example is two people each owning 50-50.
And one wants out. Maybe it's not a mutual decision. Maybe one's just like, I can't work with you anymore. I want out.
Or I've gotten older. I'm not healthy. I died. Because that's a hard discussion to have. But I mean, but nonetheless, where you're dealing with somebody's, heirs or widow as opposed to that, and if you haven't properly, planned for that, it can be difficult to. Figure out what to do, because that's and from both aspects. I mean, it's hard for the estate to protect its interest in the partnership, but the same partner has obligations to the estate.
And that gets way more complicated with all the things that come in to do with estates too.
Yes.
For our simple example here, let's just say we've got two people that at least can agree that they're not working well together anymore,
right? And
their partnership agreement is kind of silent as to what should happen in that case.
And I guess three things happen. They just decide to live with it and continue on their ways. They decide to sit down and figure out how to negotiate a settlement with regard to that, or they have to hire lawyers and file lawsuits and get receivers appointed. I mean,
so before we get to getting the lawyers involved, I mean, what are some ways to broach that conversation with your partner? I mean, assuming that things haven't gotten, completely horrible between the two of you, and you can still have, a genuine, kind dialogue of, this isn't working. let's figure this out? What are some of the things that they need to consider and discuss if it's not already, in language in the partnership agreement?
I think from that point of view, and it's not necessarily legal advice in the process, what do they both want to do? Where do they want to get to in the process? And there'll be a fight over who gets the customers. Maybe not. Maybe one of them wants to just kind of retire, get some money, and retire, and let the other guy run the business, which is one way to do it.
Mm-hmm.
The other way is the Solomon way. You split the baby, and one part takes part of the business, the other guy takes the other part of the business. I say guy, that could be women too, but they kind of take parts of the business.
I want to go back though, because you're right, it's not legal advice, but sometimes that is overlooked, because this is what happens in mediations a lot, is what do you want? At the end of the day, what is important to the person involved? And sometimes it's not necessarily about, the money. Sometimes it's well, but I just put all this time and effort, and I've got some sentimentality attached to this. I don't want to just walk away. But if you get down to the nitty gritty, it may be that in their heart they're just sick of it. They want, they deep down they might want to walk away, but they just
that happens. But they may
emotionally can't.
But there's an emotional attachment. Also, there's a money element to that, because they put this in. This is their business. This is what they do. So
you'd have to work out some kind of buyout agreement.
And another thing that comes up is that, typically businesses are financed by some kind of loan, and generally speaking, banks and most other lenders would require guarantees. So both partners have to guarantee the loan. So if the deal is one partner leaves, the other partner stays. The exiting partner would like to be released of the personal liability, particularly when he's not running the business and directly involved in paying the banks and renewing lines of credit and things like that. And that can be a sticking point.
Could partners work out these situations on their own without the involvement of attorneys?
In a simple situation where there's not a lot of external factors like bank lending and liens, and they're okay just splitting up and not competing with themselves, or competing with themselves in the process. But if there's some sort of complication to that, they built the business, one's going to buy the other one out, but he wants to make sure that the exiting partner doesn't compete. Those are the kind of situations where you really need a lawyer.
Okay, which brings us to situation 3, where things have, gotten to the point where it's adversarial and they can't work it out amongst themselves, and now we need to bring in
a lawyer. I mean, lawyers, accountants, appraisers, the whole thing. And there are a whole bunch of different kinds of businesses. There's some kind of businesses that, you have a desk and a computer, and everything else is a service. And there are other businesses where it's capital. You've got inventory and equipment and warehouses, and, storage yards and office buildings, apartment complex. There are a whole bunch of assets, and that becomes, the more assets there are to divide up, as well as the more debt there is to deal with, the harder it is, and the more steps that have to be taken.
Because let's say they've got just like an online service, and what you have is your name and the goodwill and just the reputation and the service you've been providing.
And that's
how do you divide up that?
Yeah, that's how do you divide that up in the process? Somebody's got to walk away with the website and whatever the magic code is that get you to that, and the other one's not going to have it. And attempts to try to share that, generally speaking, become awkward.
And then you have to, I guess, like you're saying, with appraisers and accountants, is having to value what that's worth, right, to come up with the number that would be at least fair and reasonable, right, for a buyout.
And then how are you going to pay it? Of course, if we have debt financing, it's the business is worth this much, but the debt against it is this much, so there's this much equity. But if you just gave half of that equity to the other partner to take everything, his name, her name is still guaranteeing the loans.
Can you anticipate any of that as you're going into the partnership? Because that's a lot. I feel like there's a lot of different angles.
There are. There are partnerships agreements that contemplate buyouts for disputes, contemplate how to handle the division of that determine, that who gets bought out, how much is paid, what the process is to determine that, what sort of time period there is for non-competes. Because if I buy my partner out, I don't want him to walk across the hall and put up a sign that says, not Hap's business, but come on over, in the process. And if I'm going to pay him a bunch of money to buy him out of the partnership, I want to make sure he doesn't compete. And non-competes is a whole topic on its own.
I was going to say that's an upcoming podcast topic.
But it's important to understand that that's in a lot of these situations, that's the biggest point of contention in that, particularly where there's going to be a buyout. I did have a case many years ago where there was a buyout clause that didn't require a non-compete. And so fortunately, my client was the one that, was being bought out without the obligation not to compete. So there was this formula as how well the business did and what his EBITDA was and what his percentage was that the other guy had to pay him. He had to pay him over time, but my guy was able to start his own business. That shouldn't have happened had they negotiated that up front. That's not a good result for the partnership or the business itself, because if somebody can walk away, require the person staying to pay them, and yet take substantial parts of the business is not good planning.
Right.
And I mean, lawyers can draft up those agreements. Sometimes the courts enforce them. It's kind of like I tell people, I can help prevent 1,000 of the million things that could go wrong in the process.
Yeah.
So there's a lot of things I can't anticipate, but I mean, there are a lot of things given experience of, the business people have had and lawyers have had, and I have had, over the years, I can predict, probably at least the 100 most common things that could cause problems and figure how best we can deal with them in the process.
Okay. Well, that's good to know. Generally, are there any other things that we haven't touched on?
Well, I mean, we haven't really talked about the true deadlock, where we have two partners who cannot agree and the business cannot operate without an agreement, in which case a court is empowered to appoint a receiver, where the receiver comes over and takes over the business.
And we have a previous podcast and a blog on receiverships.
Right. And I've done that a number of times, but I mean, it's at least in terms of the efficiency of running the business and the efforts to maximize the value for the two shareholders, partners, is not a good outcome.
Receiverships are complicated. They take a lot of time. It takes money away from where you would prefer it to be going, because the receivership has to, have its fees paid too. So if partners can avoid a true deadlock where it would need court intervention, we would advise the partners to try to do everything they can before they get to that point.
Yes. And I mean, if it's got to the point though where your business cannot operate because your partner won't do what's required to be done, and you have the choice of shutting the business down because you cannot operate or appoint a receiver, you may not have a choice. Okay,
I was going to say, given that scenario, then yes, a receivership would probably be the better of the two.
So I guess the walk away from this today is the upfront, try to consider as many things as you can. That probably involves, a little bit of money to have a lawyer, put together a good form and have the partners talk about, all the details, all the various details, and what would happen if this happened, and things they haven't thought about.
Right.
As they're anxious to go out there and do business and, meet people and sell products and do services and stuff like that. You need to nail down their own relationship.
It is good to take the time initially to make sure you've got a good agreement in place.
And then, as things happen that cause disagreements, talk amongst each other. And to the extent you cannot agree or cannot operate, as early as possible, figure out some way to divide things up, or have one buy the other out in the process, and also be sure that you don't get in a position where you are totally dependent upon your other partner if you don't think that's going to be a relationship that lasts.
Yeah.
If you need his or her contacts, financial resources, know-how, and you're completely dependent upon it when you get in a negotiation to break up the partnership, you're at a extreme disadvantage. So try to avoid that situation the best you can. To the extent you can't, recognize it, and determine how you should conduct your affairs given your situation.
Okay, good advice.
All right.
All right, thanks, Hap.
All right, this is Hap May with Legal Play.
And if you liked this, please share, like, and subscribe.